Good morning, everyone, and welcome to episode 16 of this of our series of chats about data protection, privacy, and all the related issues. Today we have Sophie Kwasny, the head of the data protection unit at the Council of Europe. So welcome, Sophie.
Hello, Federico.
We will touch upon some topics, starting from Convention 108, namely the Convention for the Protection of Individuals with regard to the processing of personal data. And then we'll move on talking about some other issues like the transborder data flows, talking about the Schrems case that started a relevant discussion on this. And then hopefully, if we have time, we'll talk also about facial recognition, and then we'll see what are the challenges for the future on this field according to our guest. So Sophie, before starting, I'll ask you to briefly introduce yourself.
With pleasure. Buongiorno, bonjour, good morning, everyone. I'm joining you from Strasbourg, and that's, I think, the first important point I need to make. I'm the head of the data protection unit in the Council of Europe in Strasbourg, because there can be some confusion about what the Council of Europe is. My office, for instance, is just facing the European Court of Human Rights. The Council of Europe is over 70 years old institution defending human rights, democracy, and the rule of law. So speaking with you today on privacy and data protection, the first flag I need to highlight is that it's a really strong, basically human rights approach that is rooted in the work we're doing. So I've been heading the data protection unit for over 10 years. At a time when I think data protection was more, a topic for specialists, and since a few years, since basically the GDPR, no one ignores the right to data protection and its importance. And I think it's really great because I consider it to be one of our most important assets today in the digital environment to protect ourselves. So, also a word about really my profile. I'm legal by education, so it's also, I think, what has enabled me in the Council of Europe to change on different topics. And actually, for 10 years, when I arrived in data protection, I thought, okay, I'm going to be there for a little while, like I've done in the past. But the topic has been so fascinating, and with such an evolution in those 10 years, that I've stayed there for a while and really enjoyed it. So Federico, thank you very much for the invitation and having the chance to have this discussion today.
Thank you for being with us. And yeah, I agree that the landscape has changed a lot in the last years, and also all the discussion on the privacy concerns of these COVID tracking apps was somehow an evidence of how let's say popular these themes are. So yeah, it's very important to share what's going on and what are the evolution of the legal and social impact of these issues. So let's start from Convention 108, and with a very general introduction, because I mean, it was approved in 1981, so it was enforced in 1981, so a totally different word, and then modernized in 2018, so the same year when GDPR was enforced. So what are I'd ask you to guide us through this process of approval and then modernization of this very important convention.
Okay, but so first, it's speaking about 4 decades of work in a very short time, which is a
Yeah,
challenge.
I
So
know.
I'll just give you the main highlights. So indeed, as you said, 1981, and we just celebrated this year the 40th anniversary of the convention. What is important to highlight, you gave the full title of the convention because it's known, the short name is 108, which is the registration number in the treaty office. But the full name, as you said, is Convention for the Protection of Individuals with regard to the processing of personal data. And I think it's really important to highlight the title because it gives you exactly what data protection is about. It's not about security of data, protection of data, technical protection. It's about protecting individuals. It's about protecting you. It's about protecting me in the exercise of all our rights when our information, personal data is being processed. And this started 50 years ago, even if we look at the first data protection law in Europe. But with the advancements of the technologies, this right, which now is really affirmed like a fully independent right, not solely depending on the right to privacy, but fully independent and autonomous. Well, this right has really gained significantly in importance and has been developed with new features. That's the evolutions of rights. You have several generations, and what we now have today, which is the modernized convention or the GDPR at EU level, is really a robust and solid system which encompasses a number of rights for us, but also new rights, meant to defend us in this algorithmic environment we're in, with fully automated chains of decision being made about ourselves, and so how can we keep in control of our information in that context? So that's already one illustration of this evolution, those new rights. You also have new obligations for those that are using our personal information, our personal data, and something that really came in this last generation of text is the accountability or privacy by design, privacy by default. So all those novelties are now embedded in those legal texts. And what is great about Convention 108 is the vision that the drafters had of it 40 years ago. They immediately understood that in order to facilitate the circulation of information, because it's what the right is about. The right is there or the convention is there to enable countries to adopt similar laws to create a common legal space. And in this common legal space, of like-minded countries that agree on the definition, for instance, of what personal data is, but also on the obligations and the rights, then you can have a zone of trust, of confidence, and then of reciprocity with the data circulating. And so immediately the drafters of the convention, not even, of course, thinking about internet and the tools we have today, already seized the necessity to facilitate the circulation of this information, and provided us with a tool at international level, which is a treaty, which is precisely there for that. And in those 40 years of existence of the text, which was born in Strasbourg, which was born in Europe, we completely see that this global potential of the text is materializing. We now have 55 countries, so it's also African countries, Latin American countries that have committed to respect in their law the provisions of the convention. And what is also great is that the convention establishes a committee. So we meet in Strasbourg twice a year, and you have those 55 countries plus observer countries that want to contribute to the work. And this committee is basically a group of 70 countries, all regions, all continents of the world, participating together on some work, on documents, opinions, soft law instruments that shape our rights, the evolution of our right to data protection in light of the new challenges we're facing. You mentioned facial recognition. That's, I think, a very good illustration, and we can come back to it later. But so really, what is amazing is the vision they had of this tool at international level that would allow country to commonly work together, cooperate, exchange data, which is crucial, and the fact that there is still no other equivalent for that. The treaty is unique. There is nothing at UN level, for instance, and so it's actually more important today than it's ever been with the modernized form, because indeed we had to tackle new challenges, this new environment we're in, and managed to deliver in 2018 the modernized treaty, which is 108 plus, which responds basically to all the latest challenges and needs we've been facing. I could continue for hours, Federico, if you don't stop me.
Yeah, I know that. I would say that you gave us a perfectly clear framework of the scope of the convention. And also this interesting, it's very interesting what you pointed out about the fact that in those years, the flows of data in the digital form, let's say, was not that relevant as it is now. So it's very interesting to see this vision from the authors of the convention. And also, this leads me to the second topic that I'd like to address today, which is exactly transborder data flows. So I mentioned the Schrems case before, to summarize. In July 2020, the Court of Justice of the European Union invalidated the EU-US Privacy Shield. So the case originated from Maximilian Schrems, an activist, who called for the Irish Data Protection Commissioner to invalidate the transfer of personal data by Facebook from European Union to the US. So this sentence had a very strong impact and started a big discussion on if we have to think about how to enforce what is already there as for the legal framework, international framework for data flows, or if there's something to do to harmonize European and other continents' laws. And a lot of people pointed to the GDPR as an example of how to proceed in this way. I don't know if I summarized correctly the situation, but I guess that more or less this is the framework. So I'd be interested in your thoughts on that and what the Council of Europe is doing about that.
Yes, thank you. So transborder data flows is also, I think, even more relevant today. You mentioned it. You mentioned the sanitary crisis we're all facing. You took the example of the contact tracing applications, but there are a number of challenges that have been raised in that context, because for all of us, our lives, our work, our socializing has moved online with immediate data and ubiquitous data flows intervening instantly at the moment we're using those tools. And so this question is essential, because we should be able to expect that the level of protection we're being afforded in our country prevails whenever our personal information is being used. And for that, you can use technical tools, but you also have legal tools. And once again, it was really the raison d'être, the rationale of Convention 108, which was to ensure that when data were crossing the frontiers, the protection was being maintained. And there, because you take the excellent illustration of the case of Schrems 2, I will really touch upon the articulation between the EU framework, because this is a decision of the Court of Luxembourg, as you said, and the convention, and how this can respond to the challenges. One thing I'd like to say first is to commend and thank Maximilien Schrems, because, you know, it's this depersonalized word now, Schrems 1, Schrems 2, but behind that you have an amazing man, Max Schrems, who's been fighting like David against Goliath for years. He started when he was a student with, zero means against Facebook at the time. Schrems 1, he had the invalidation of the at the time agreement between the EU and the US for data flows, and then with Schrems 2, again invalidation of that bilateral agreement, allowing data to flow from the EU to the US. And what he's been doing is simply amazing, and actually is using the tools, the legal tools that are being given to him. And it's great that thanks to the GDPR, I think it's really one of the strong added values of the GDPR, you can have a collective defense mechanism of the rights with NGOs, and the NGO is created. NOIB is exactly doing that, and we need, I mean, there are others doing it in France, there are a number, I know in Italy there are a number, but we so much need, that defense, all those little David fighting the Goliath with the legal means we have. And so there, what happened with this case is that the Court of Justice struck down the agreement that was passed on two main legal points: lack of legal remedies for us EU citizens in the US when our data was being transferred, and problems in the safeguards and proportionality of the access by national security agencies, US national security agencies, to our data. And so this is where the link with Convention 108 and 108 Plus is essential, because the convention deals both with private sector processing. That's what we require to our parties in their laws, to make sure that when our data is being processed for commercial purposes in the private sector, all the rights are respected. But it also imposes obligations for the public sector, law enforcement, national security agencies, and in a really strong and balanced manner for Convention 108 Plus. You have an Article 11 in Convention 108 Plus, which was one of the most eagerly debated articles in the negotiation of the modernized convention, also with the article on transborder data flows. And we see why the two are connected, because with Convention 108 Plus, what we can ensure now globally, with as many countries joining, is ensuring that even in this complex and sensitive field of national security, have a level of protection that is afforded to our data. So the right to data protection is not absolute. That's the first thing we have to recall. There can be limitations brought to it. It's the European Convention on Human Rights, Article 8, right to private life. Same thing with freedom of expression. There can be limits brought to it. But when you come and limit a fundamental right, you need to respect very strict conditions. And so with this Article 11 of Convention 108 plus, we basically take this protective mechanism of the ECHR that says if you limit fundamental human rights, you need to have a law, you need to pursue a legitimate aim, for instance, national security, and you need to ensure that the measures you are taking are necessary and proportionate. And then we foresee other requirements. And so you find this in Article 11 of Convention 108 plus. So it's a tool for any country in Europe to ensure that country X, Y, Z outside Europe, by ratifying the convention, actually protects our personal data when their national security agencies are accessing our data. So we see today that there are discussions in the US, because Schrems 2 is about US-EU relationship. We see discussions in the US about a federal data protection law. This is essential. And what would be essential is that once this law is in place and complies with the provisions of the convention, we have the US ratifying the convention, acceding to it, and basically ensuring that this protection exists. Because the more, as I said, the more a country will have coming and making this international commitment, the more protected we will be. There was, after Schrems 2, there was a wave of reactions, and one of the reactions was, oh, we need the Global Data Protection Convention. No, the Global Data Protection Convention already exists. It's Convention 108 plus. But what we need, because Convention 108 plus is about data protection, but then it would be really important at the international level that there is an agreement on what intelligence agencies can do, how they can operate, what democratic oversight is needed. So this piece of the puzzle is crucial. It's complementary to 108 plus, and there are already elements in 108 plus. But indeed, I think once again, I've been amazed by the powerful effect of that decision in July. The consequences are not yet final, and we still need to see what will be the next instrument regulating those bilateral flows between the EU and the US. But at the same time, it's not only US, EU, tomorrow it's China, it's India, it's any other regions where we know our data are flowing. And so once again, there the articulation, and that's why the EU is so much promoting Convention 108 plus. It's filling a void and a gap, which is the GDPR is indeed what is presented as the gold standard for all the private sector processing. But for this part, national security, the EU is relying on Convention 108 plus and its mechanism.
Yeah, and also, as you said, tomorrow it would be China or other countries and continents, but it's today, and we shouldn't wait for another Schrems to take the lead in this challenge. So it's very important to underline that there are tools like the convention that are already in place to move on. And sometimes the narrative is, okay, we should do this, just to point the attention to something else, something bigger and hard. And but actually, as you said, it's also a question of national security and democracy. And I mean, it's a very interesting issue. And I see there's already a question in the chat, so let's address it now, if you agree. Inigo asks us if, according to you, there is the convention is somehow in conflict with the EU data protection regulation.
Good question. Absolutely not in conflict, and really the contrary. Completely consistent, compatible. Two reasons for that. Chronological reason. Convention 108, 1981. The first EU data protection instrument was not the GDPR in 2018, but was a directive from 95. And in that directive, you found in one of the recitals a language that said this EU legal framework for data protection amplifies and develops the principles of Convention 108. Because it's obvious, you have the EU countries that are all parties to 108. And so how would you want Italy, Spain, France, if I take our three countries, to be bound by two different legal frameworks that are contradictory? Impossible. So they are fully consistent for a very good reason, is that in the EU, in developing its framework, always took into consideration the original text of 108 and went further. That's really, if you want, the logic of developing the standards and being more prescriptive. And that's exactly what the Directive of 95 and the GDPR have been doing. But also, as I said, the EU now really counts and values 108 plus, also because in the 2011-2018, that's the 7 years it took us to negotiate 108 plus, the European Commission was at all our meetings representing the EU and ensuring that what was being done in Brussels about the GDPR and the law enforcement police and justice directive was in full compliance with what was being done in the modernization of 108 plus, to avoid any contradictions. And so it's been not always an easy work, but I think the result is there. You also find in the GDPR, in one of the recitals, it's 105, a reference to Convention 108, because the two frameworks are absolutely compatible and consistent.
Okay, since there is a follow-up questions always by Inigo, I'd ask Inigo if he wants to take the floor and ask directly.
Okay, thank you so much, Federico. Sorry, I was not ready, and I'm not in a live chamber. So anyway, I hope that you can see me quite well. Sophie, thank you so much, really, for your presentation. It was, really brilliant. But I could not avoid just asking you some. I know that those are quite hard to answer questions, but I totally agree with you on the idea that until now, yes, the Commission, or maybe the EU regulation and the Convention, have worked well together. I don't know if this is also be the same in the future, especially keeping in mind the drafts that have been elaborated. I mean, for example, the Privacy Regulation and the Data Governance Act, and to my knowledge, the draft of the I regulation. I know that this is even in conflict inside the EU framework and the EDPB and so on. They are, raising issues that are embedded in these new proposals. But I would like to know your opinion if this is not too conflicted. I mean, I would really love it.
Yeah. Thank you, Inigo, but I think I have a very diplomatic answer to make to you, and you've already given that element yourself. That is, I think the first element is that those drafts, and there are still drafts, and the AI regulation, it's a leaked draft still, and the second version of the leaked draft. So it's still too early to tell, but the first, clearly the first response is that all those regulations should comply with the GDPR, obviously.
Yeah.
That's, I mean, there can be no other way. It's impossible. And then a hint, if there is a tension between the GDPR and those instruments, you can be quite certain that there will be a tension with Convention 108 and 108+2, because the GDPR is fully aligned. The GDPR goes further than the Convention in some respects. For instance, this collective right I mentioned, you don't find it in the Convention. The right to portability, there are obligations you won't find in Convention 108+, because it goes further. But so clearly, I think it's for the legal services in the EU. Yeah, it's better with the light. I see you better.
I look better. Yeah, I look better with the light on. Yeah, indeed.
It's for the legal services to ensure that any and you mentioned the EDPB and the EDPS that is consulted on any piece of legislation to ensure that the legal acquis in data protection is respected for any new piece of legislation. They have to make sure that that this is compliant. Otherwise, we will be facing the same difficulties with the articulation with Convention 108.
Great answer. More or less, I thought the same, but good to hear it. Sophie, thank you so much.
You're welcome. Gracias.
Yeah.
Yeah, and just to specify, it was Íñigo de Miguel from the Basque Country University, who is a project leader.
Merci. I should say merci then, Íñigo.
Yeah. Okay. Yeah, let's move on. You mentioned the AI regulation, and I'd like to talk a bit about the problem or the issue of facial recognition in the European Union, namely, but in general, because we have some associations that are campaigning against the facial recognition, and also there was a letter from a number of MEPs to the Commission calling for the ban on biometric massive surveillance. So it's a very hot topic, and there are regulations that is in the making in this field, and in general on the AI. So yeah, I'd like to have your point on this.
Yeah, it is a very hot topic, and it is a very important one. Also, then to come back to the more general level, but I think it's important to highlight it again. As I said, you know, the right to data protection throughout those decades of implementation has really gained its independent and autonomous form, and we really see it as the right that enables us to fully exercise and enjoy other rights. And the best demonstration we can give is actually facial recognition, freedom of assembly, freedom of expression, and the fact that with those technologies, you could curb and limit freedom of assembly, manifestation, while the right to data protection there is one of our elements of defense in saying, no, this cannot be done. And so in saying this cannot be done, or this can be done, we have been providing our little stone to that building. It's a non-legally binding text, so it's soft law, it's guidelines, but we thought it was really important for the committee of the convention to also provide this guidance. And so you can find it on our website if you tap Council of Europe guidelines facial recognition. It was adopted in January by the committee of the convention. So already I want to highlight the authority and the legitimacy of this document. It means it's the 55 countries that are parties to the convention that have adopted that document. So you have 55 representatives either of governments or data protection authorities, but all data protection specialists agreeing on that text, which is threefold in its construction. First, we target the policymakers and the legislators in telling them, look, you need a legal framework for that in place, because we're speaking about sensitive data, biometric data, uniquely identifying a person. And so this is highly protected under our data protection standards. So first, a legal framework, and then saying what this legal framework should include. A second part of the guidelines is about those that are actually developing the technology. So some technical requirements also. And the third target group is those that are using the technology, what we call the controllers in data protection or processors. And finally, a part on our rights as individuals when our data is being processed. And I think in those guidelines, you will find really strong and excellent language on the need for a democratic debate and possibly a moratorium when we are speaking about a live facial recognition in public spaces in light of the intrusivity of those techniques. You find a very strong language on a ban or a prohibition of some forms of use. For instance, possibly discriminating on the basis of race, age, all the standard the standard discrimination fields you find. Also highlight as to a ban for what is called affect recognition, which is even more sensitive, and we already see quite a development in its use. So you already find those very strong elements. There's also, I think, a very important in the guidelines, which echoes the Clearview scandal, of the fact that you have all those faces published by people on internet, on social networks, doesn't mean that you can capture it and use it for other purposes. When you do that, you need another legal basis to ensure that the processing is lawful. You also find that in the guidelines. And then the guidelines, if you want, that's to give you an illustration of what the committee is doing. The committee is taking the backbone of the convention, because the convention has very general, high-level principles, provisions, I would say, and then the committee describes it in particular concrete and pragmatic aspects. And so, for instance, what does a lawful basis means in the context of facial recognition? And there we differentiate two cases: public sector use, for instance, law enforcement; private sector use. And clearly, it's said that in a public sector use, you cannot rely on consent to legitimize the processing. So you need a law for that, a legal basis, as legal basis. For consent in the private sector, because there you can rely on consent. For the consent to be free, there needs to be alternatives offered. And so, it can be a card code or other technical facilities. Otherwise, the consent cannot be considered as free. And if it's not free, it's not a valid consent. So basically, the guidelines, they explain all that in the context of facial recognition. And it was quite broadly covered by the media. And I think it should be used now in the Brussels. And that was the intention also, that this, as I said, this piece of the puzzle is used in other negotiations that are taking place, because I think there are really strong and protective elements in the guidelines that we need, because, as you said, there will be regulation coming on those topics, and the societal impact of those technologies is beyond what we can guess now.
Yeah, and I put the link to the guidelines in the chat, so if anyone wants to download it, it's there. And yeah, thank you very much, Sophie. We are more or less in the last part of our chat. So if someone else has questions, please, you can whether type them in the text chat or raise your hand. There's an icon at the bottom of your screen, and I'll give you the word. Before saying goodbye, I'd like to briefly outline the prospects for the convention. So we see that it has quite a long story, and one of its main positive points of strength is its vision. So I guess you are already trying to envision what will be the future. So can you briefly talk us about that?
Yes, but yeah, but it's what we've done actually in those years of modernizing the convention, and really, I think the modernizing exercise enabled everyone that was there negotiating the text, and as I said, it was really from all regions of the world, to understand that it's a tool that unfortunately is not enough known for a variety of reasons. But that if we now wait on UN to legislate on that, it will take another decade. The result might not be as excellent, because Convention 108 Plus is excellent when you take the complexities of an international negotiation at so many. So we might not have the same result. So really, my message is to seize for our future. We need to push all governments to adopt legislations that comply with Convention 108 Plus, because once again, this article on national security exceptions is fundamental for us today, but also the other parts on those new rights I've mentioned. And another strong element is our data protection authorities, and the need for their independence, the need for them to have the means to function effectively. This, we have seen throughout the years, is an essential element of our protection. So only to call to all governments to ratify, to enable the entry into force of the modernized instrument, which the more it will spread in the world, the more we will be protected. So clearly, if I look, there is there is a regular count of the data protection laws in the world. Today we count 145 data protection laws in the world. I told you we have 55 parties to the convention. So you see there's already a big gap. And it's partly because some of those data protection laws don't go into the level of detail and now prescription of the convention. Though there needs to be upgrades of those laws. You need, as I said, the US, for instance, to adopt such a law. And so that's really an impetus we need to maintain. More countries enacting data protection laws, and more data protection laws matching Convention 108 Plus for all of us to have an effective protection.
Thanks a lot. I will read, I would say, the last question we have in the chat by Mikel. What about cross-border sharing of personal data for scientific research purposes? Is there any priority for the Council of Europe to push for a common framework, especially after the advent of COVID-19?
That's something we actually recalled in at the beginning of the crisis, so a year ago, and I said it, the right to data protection is not absolute. So it needs to be balanced in light of other fundamental rights, public interest. Public health is one, obvious one. And research, scientific research, is clearly mentioned in the data protection instruments as, for instance, what we call a compatible purpose. You have one of the core data protection principles, which is the principle of purpose specification. That is that when you are going to process personal data, you need a specific and determined purpose for that, and that purpose needs to be legitimate. And so each of us, we should know why, basically, in which intention our data is being processed. And so that's something you set at the beginning. And so I'm being told that using this tool, my data will be used for this and this and that. And here, with this notion of compatible purpose, we say that even if the data was collected for this reason A, then using this data for reason B, which could be scientific research, but it could be others. There are others grounds for this extension of the compatibility. It allows you already to use some data that was there use it in a scientific research purpose, with, of course, appropriate safeguards, and we know them in research. There are a number of safeguards like pseudonymization, for instance, that can be used. So only to highlight that data protection is not there to block scientific research or to impede it. Clearly, the texts allow for this equilibrium, and then the question of transborder aspect of the use of data in the scientific research is another one, but there again, in any transborder data flow regimes, you have the core principles, and then you have exceptions that can allow you to let data flows for a particular reason. So I think that in all good intelligence, there are means to enable that data that have to be used for scientific purposes be used and be able to cross our frontiers.
Great, thank you very much. I guess we covered a very broad range of topics in just more or less half an hour. So let's stop here and make some thoughts, and of course let's be in touch for other possible collaborations among Panelfit and your unit and the Council of Europe in general. I take this opportunity to announce that the next monthly chat will be on the 12th of May with another representative from the Council of Europe, which is Patrick Pennix.
My boss. My boss is great. You have to be there. He's really great, and the department, the Information Society department, is dealing with so many fascinating and interrelated topics that it will be, I'm sure, a great session and discussion too.
Yeah, I look forward to that. So thank you very much once again. And
thank you very much for your invitation and the discussion. Thanks to everyone for the questions and interaction. Thank you.
Thank you. Goodbye.